Hello, and welcome to the video segment for the Legal Environment of Business, Business 6018. This is the introductory video. This video segment covers the first module, which includes chapters 1 through 3 of your textbook. The video segment serves as a preview to the class discussion or a review of the class discussion. It's not to serve as a substitute for your attendance to class. In this segment, we're going to be discussing the U.S. court system, as well as judicial review and personal jurisdiction. The PowerPoint that you'll be seeing is also available in modules. It also includes some important content for the syllabus, and I highly recommend that you take a look at the actual PowerPoint and not look at the video here. There's some more stuff on there. You'll want to take a look at the PowerPoint. So let's talk about the U.S. court system. The U.S. court system, particularly in the civil arena, is important because some type of system needs to be in place for the purpose of resolving disputes between individuals and other individuals or individuals and entities. Again, we're talking about the civil court system as opposed to the criminal court system, which is a whole different animal as part of our U.S. court system. The U.S. court system originated from the English common law, in which you had cases that were brought before the court in England, and those cases were decided. And based upon the doctrine of stare decisis, many of those cases still stand and are cited as good case law in current cases that we have today in the United States. Stare decisis is Latin for the term to stand on existing law. And anytime you have somebody who's a candidate for a Supreme Court justice come before Congress, they usually talk about how they're a firm believer in stare decisis, in letting existing case law stand. Cases are not overturned by judges or justices unless there's a compelling reason to do so. So we like to let case law stand for the purpose of consistency and predictability. When it comes to the power of the courts, in particular the power of the Supreme Court, the Constitution, Article 6, makes reference to the fact that the U.S. Constitution is the supreme law of the land. Below the U.S. Constitution, you have state constitutions, and below that you have federal, state, and local laws. And below that you have laws that are passed by administrative agencies, and then coming at the very bottom is common law court cases. And that's the type of law we look at and we use here in the United States. Another important thing to know about is the Bill of Rights, the first 10 amendments that were ratified after the U.S. Constitution was ratified by the states, and particularly with regard to Amendment 10 that says that whatever power the federal government does not have, that is then relegated to the states. It's part of the Great Compromise that prohibited the great centralization of power on the federal government by also saying the states have powers as well. We have two different types of law systems, apples and oranges. We have the civil law system, which again speaks to disputes between individuals or individuals and entities, and the criminal law system that deals with wrongs against society. And in the criminal law system, you have cases or charges that are filed by either the state district attorneys or the federal U.S. attorney for crimes committed by individuals or by entities. The people who hear those cases, either civil or criminal, are judges and justices. Judges are those who hear cases on the trial court level, and all those who sit on courts at the appellate level, whether it's the appellate court or the Supreme Court in the state or the federal government, are known as justices. Well, you know about jurors as well. There are people who are impaneled to hear the case at the trial court level and rule on issues of fact, while judges rule on issues of law. Lawyers are the people who argue the cases. Lawyers are not held in great favor, but as the old saying goes, nobody wants a lawyer, nobody likes a lawyer until they actually need one. And so hopefully you won't be needing one in your lifetime, but chances are, if you're running a business, you're going to need to have a lawyer. When it comes to the court system, both state and federal, you have the trial courts, which is where the trial is held. Witnesses are examined, exhibits are submitted, But at the appellate court level, both at the Court of Appeal and the Supreme Court, there's no new trial. Briefs are submitted before the appellate justices, the cases are argued, but no new trial takes place. That all takes place at the trial court level. Well, let's talk about getting into court. In order to get into court, you need to have the nexus of three things coming together: standing to sue, personal jurisdiction, and subject matter jurisdiction. You got to be in that sweet spot right in the middle in order for all three to occur for you to be able to successfully get into court. Let's talk about the first one, standing. Standing means that you have some type of involvement in the actual case or controversy that comes before the court. You have a personal stake in the resolution. To put it bluntly, you've got skin in the game. It matters to you. It sounds pretty straightforward, but you'd be surprised how many people file lawsuits in California, and it's eventually found out that they really have no involvement in the case and no standing to sue. More often than not, they're after a fast buck. Along with standing, you have to have a personal jurisdiction over the person that you're bringing into court. If I'm driving along Interstate 8 outside our building here and I get rear-ended by somebody else who lives in San Diego, we're both here in California, we both live here, the court in California has personal jurisdiction over us. If I'm driving in Arizona and I get rear-ended by somebody who lives in Arizona, and they've never been to California, it's going to be tough for me to go back to California and file a lawsuit against them because the court in California will say, sorry, Boldinger, we have no personal jurisdiction over this individual who lives in Arizona. But there are ways of kind of getting around that. We have long arm statutes based on minimum contacts, which make it possible to reach out and grab somebody from the other state. If that person who lived in Arizona was here in California and rear-ended me out here on Interstate 8, the fact that they were here when it occurred, even though they don't live here in California, the court in California can have personal jurisdiction over them because of their physical presence. There's a lot of other ways the long arm statutes can establish minimum contacts with individuals in a given state, and we'll cover that more thoroughly in class. So we've got we have the standing, we've got personal jurisdiction over the person. Now we need to have jurisdiction over the right court that has the right subject matter jurisdiction. Okay, the power to hear the type of case. Jurisdiction, literally translated from the Latin, means juris, law, diction, to speak. The power, jurisdiction is the power to speak the law. And so we got to pick the right court. We need to pick a court if we have our automobile accident rear end case. We need to pick a court in California that has general subject matter jurisdiction. That would be Superior Court. We don't want to file in a court in California that has limited jurisdiction like divorce court, probate court, small claims court. They only hear those types of cases. They won't hear my motor vehicle accident case. So you got to pick the right court that has the general subject matter jurisdiction. On the federal level, you have the same issues. On the federal level, you can file a lawsuit in one of two areas. When you have a federal question dealing with constitutional issues or a federal law, you can file in federal court. The Federal Court of General Jurisdiction, not a Federal Court of Limited Jurisdiction dealing with bankruptcy or tax court or patent law. If you have a federal question, you can file in federal court, no dollar limit. There's also, you can also do it with diversity of jurisdiction. If there's diversity of jurisdiction, diversity of citizenship rather, let's go back to our hypothetical. One person lives in Arizona, I'm rear-ended in Arizona, I live in California, we have diversity of citizenship. I can file my lawsuit in federal court for the personal injury if the claim is over $75,000. Got to have diversity of citizenship and a dollar value of over $75,000. Federal court system, again, mostly trial courts, Court of Appeal, and the Supreme Court of the United States. But you've also got tax courts, various types of administrative courts, the Patent and Copyright Court, as well as the Bankruptcy Court. A lot of different courts in the federal system of limited and general jurisdiction. The district court, the trial court, has the trial. gets exhibits, hears witnesses, but the appellate court, once again, does not have a new trial. You submit the briefs, you argue the case either before the Court of Appeal or the U.S. Supreme Court. There are several appellate courts in the United States. The map here shows 11 different areas of the United States where there's different courts of appeal. There's 2 more on the map that aren't listed, both in D.C. One is the D.C. Appellate Court and one is the federal court. One has to do with patents and copyrights. The other one is an appellate court. The U.S. Supreme Court. In order to get there, you got to file a writ of certiorari. If 3 out of the 9 judges review it and say, yeah, we'll hear the case goes before them. Far more cases get declined than get accepted, of course. And the U.S. Supreme Court usually accept cases that in which there's federal importance, a big constitutional issue, or they want to clear up conflicting decisions at the lower court level. But once that case goes before the U.S. Supreme Court, it becomes a supreme law of the land, and all the other lower courts have to follow it. So it's kind of a big deal. Finally, we deal with judicial review. That's the power of the court. They have to interpret legislation and the Constitution to determine the constitutionality of a particular law or an action. You'll want to review the Marbury versus Madison video. It's a great viewing, and it's particularly poignant. We think we live in polarized times now with regard to the political system. Back then, with the outgoing Adams administration and the incoming Jefferson administration, you had a lot of polarization back then between Federalists and Anti-Federalists, and it's all on the stage of Marbury versus Madison. But it was in that case that Chief Justice Marshall said that it is the role of the judiciary to interpret law and determine whether or not a law is to be considered constitutional, which is kind of a big deal. It's not really referenced in the Constitution. Justice Marshall created his own job description in Marbury versus Madison, and it's been followed all of these years up to the present. So watch that video and get an understanding of what that case is about. And if you have any questions regarding what I've just covered, stick around for the class session. Hopefully we'll fill it out and answer your questions you may have. Otherwise, you can reach me via email at tlbollinger@pointloma.edu. Almost gave you my firm email. Otherwise, if I don't hear from you, have a great day. I look forward to seeing you in class. Stay safe.